back to Trial by Podcast, where we discuss the latest legal development and controversies. I'm Meaghan.
I'm Mariana.
And I'm Fadi, and today we'll be looking at what has been described as a business dispute between Recipe Tins Eat founder Nagi and baking influencer and author of Bake with Brooki, Brooke Bellamy, which has triggered a lot of discussion around recipe plagiarism and possibly even copyright infringement.
So before we get into the layers of this dispute between caramel slice and baklava, let's give a brief introduction into the authors and the publisher at the center of this not-so-sweet ordeal.
Born in Japan and raised in Sydney, Nagi founded her renowned food blog, Recipe Tin Eats, in 2014 after giving up a career in corporate finance to pursue her passion of food and cooking. And her website now has 500 million views each year, and she's amassed astounding 6.5 million followers across social media, becoming every Aussie's trusted cooking companion. And she's since published two wildly successful cookbooks, Recipe Tin Eats, Dinner, and Tonight.
So dubbed the Cookie Queen, Brooke Bellamy began in Brisbane's Fortitude Valley, where she transitioned from being a travel blogger to a cooking queen. She became a viral sensation with her day-to-day life in the bakery videos on social media. Brookie's Bakehouse gained a cult following, with daily queues of people lining up to try the cookies and over 2 million TikTok followers. In 2024, she launched her debut cookbook, Bake with Brooki.
So there are allegations that have also been made against Penguin Random House Australia, so we're just going to briefly touch on them as well. They are, according to their website, the world's largest trade book publisher. They are also the publisher of the cookbook in question. Notably, in October 2024, Penguin, in stark contrast to other academic printers such as Taylor and Francis and Oxford University Press, who agreed to license their portfolios to AI companies, took a strong stance against big tech's use of their copyrighted works to train the AI models.
Now let's get into the actual allegations. On the 29th of April 2025, Nagi leveled plagiarism allegations against Penguin Random House Australia and Bellamy in a blog post titled "When You See Your Recipes in a $4 million book." Nagi stated, "While recipes can resemble one another, because there are only so many ways some recipes can be made, the precision and the detail in the similarities in this case are, in my opinion, far too strong to be a coincidence." She also ended up giving readers a side-by-side example of the ingredients, quantities, and methods of her and Bellamy's published recipes for caramel slice and baklava. Both Bellamy and Penguin Random House Australia have rejected the allegations, asserting that all 100 recipes in the cookbook have been crafted by Bellamy since she began selling her creations commercially in October 2016. In her Instagram post, she stated, "Recipe development in today's world is enveloped in inspiration from other cooks, cookbook authors, food bloggers, and content creators." And that's not the end of it. More plagiarism claims have since emerged internationally, with American baker Sally McKenney, known as Sally's Baking Addiction, claiming that Bellamy had plagiarized her "The Best Vanilla Cake I've Ever Had," published in 2019.
So on 24th of May 2025, Brooke broke her silence and came out with a statement on her social media that said she was always been very excited to share these recipes since she was young. They've been handed to her from friends and family, passed down generations, scaled for the bakery, and some have been inspired and influenced by bakeries across the world. Interestingly, she said, "Whilst all these recipes are personal to me, I cannot say that I've invented the cookies, cupcakes, brownies, and cakes in the book. They are all inspired from somewhere or someone before me."
You know what? I think it's interesting that one of the common words of choice when we're discussing this dispute is plagiarism. I think we need to bear in mind that plagiarism and copyright are neither synonymous nor mutually exclusive, contrary to what I think some of the articles kind of imply to maybe the regular reader. Plagiarism may exist where copyright infringement is and vice versa, but they don't necessarily need each other to occur.
That's right. So in an article submitted to the International Journal of Legal Science and Innovation, Ginger Shah, in his work Plagiarism, A Torturous Act, identifies that this concept of plagiarism is usually limited to academic work or research, and it's not typically part of legal cases. It's typically grounds for disciplinary action, so might be suspension or expulsion from educational facilities. but not legal action. So bearing that in mind, as you said, Mariana, these concepts of plagiarism and copyright infringement are nevertheless mutually exclusive.
Exactly. Plagiarism typically involves the use of someone's ideas, expressions, or written work without proper attribution. And that might speak to some kind of an affront on a moral right, for example, especially where users are passing them off as their own, as in an academic setting, as you just canvassed. Plagiarism is an ethical offense, and it's usually an ethical offense against the author, and obviously anyone relying on the work and trying to maybe credit it themselves. So if they wanted to see any kind of derivative work, they would want the proper authorship. Copyright infringement, on the other hand, violates the exclusive economic rights of an individual. These might include reproduction, distribution, communication to the public, or adaptation. And these rights obviously subsist in the copyright itself. So any individual that has copyright will or could be referred to as a rights holder. It is an offending act against the copyright holder, and infringement can occur when someone, firstly, takes the work as a whole or a substantial part or sufficiently original part of it without licensing. So permission of the copyright holder is a necessary prerequisite to actual use of a copyright protectable work. In the absence of an applicable statutory exception, and where the use is commercial in nature. Therefore, if an entire original work, for example, a PhD thesis published in a book, or a substantial part of it were plagiarized for economic benefit, theoretically, this would amount to both an infringement of a moral right, so there's ethical rights we were discussing, and copyright infringement. Mayahashi herself has seemingly acknowledged that she understands this difference and the nuances relating to it. She states verbatim, "Profiting from plagiarized recipes is unethical, even if it is not copyright infringement, and undermines integrity of the entire book." I think the pertinent question is, however, which of the two, if either, might Bellamy be found guilty of, allegedly?
So thinking about Nagi's first statement, she says the similarities between the recipes in question are far too specific and detailed to be dismissed as a coincidence. Could these similarities between recipes amount to copyright infringement?
Yeah, I think that's a really complicated question. And to answer that, I think we need to start from the beginning, which is to identify what copyright actually protects. So in Autodesk and Dyson, Justice Dawson clarified, it is fundamental that copyright protection is given only to the form in which ideas are expressed, not the ideas themselves. So the idea of a caramel slice recipe or the idea of a baklava recipe are not in of themselves copyright protectable. It's the way that these recipes express that they might be protectable.
Exactly. So under the Copyright Act 1968, recipes are literary works in which copyright may subsist in. Importantly, copyright only extends to original works. The court, in the case of Telstra Corporation Limited and Phone Directories Company Propriety Limited, critically clarified that the Copyright Act only affords protection to expressions that take a particular form, and these expressions must have originality and some independent intellectual effort. With this in mind, I can understand why intellectual property academic and Macquarie University lecturer and my lecturer, Daniela Simoni, asserted that a set of ingredients, the ratio for their inclusion, a basic cooking method, and a standard recipe layout are all examples of unprotectable ideas.
When we apply copyright law to this dispute, we can see why Nagi hasn't chosen to litigate. It's genuinely hard to tell whether there's any infringement here. The two recipes posted side by side certainly look similar, and that's stirred subsequent considerable public concern. But as Simone notes, copyright protection for recipes requires minimal input, and to be original enough in copyright's eyes, a recipe should not be an exact copy of another. She also added the simpler the recipe, the more exact a written copy needs to be for the infringement to be established.
Yeah, and I think what becomes abundantly clear from that, Mariana, is that recipes present unique challenges in copyright law. I think everyone, when they first heard of this debate, kind of jumped the gun and said, there's two recipes side by side, there's a few words reorganized. Brooks reformulized Nagi's recipe by changing the few words. But I think everything we've discussed, this might be enough for Brooke to gain her own copyright protection in what the Telstra case suggested. It's in her own particular form. So even if Bellamy had come across Nagi's recipe, read them, and then modeled her own recipes from that in her own cookbook, it might not even matter because those minuscule changes in the phrasing, the listing, could constitute an entirely novel piece of work that's copyright protectable.
So hold on, let's say, for argument's sake, she did exactly that. Do we think that this is a shortcoming in the law? Should chefs and cookbook authors be able to afford their recipes copyright protection?
So I think that we would end up in a particularly bad situation if we chose to accept this. Not only do recipes once published and obviously disseminated in the form of a cookbook form part of the public domain, so many recipes are also know-how processes. So you might learn a recipe from your family or your friends, or just kind of your own invention that you've just chosen not to write down, for example. There are a million caramel slice recipes online in cookbooks or maybe YouTube tutorials. And I think the question would become, well, with who does that copyright, that original copyright protection, who is that vested with?
Yeah.
And when so many recipes, and Bellamy has expressed this herself, are bound to share common steps and measures, the question also becomes, well, to the extent that a subsequent recipe or a derivative recipe, or even just a recipe that remodels an original recipe, uses those measures, to what extent would we need a licensing agreement as well?
Yeah, and I think it'd be counterintuitive to the goals of copyright and intellectual property generally, which is mediating between affording rights to rights shareholders and at the same time ensuring continued creativity is not hampered. So this whole debate has also raised some questions as to whether copyright is the sole mechanism of intellectual property that could safeguard a recipe. And as Rachel here said, the answer is not straightforward.
Yeah, exactly. So, and what you'll find with IP is that there's generally a lot of overlap between the rights you can have and the rights that might protect your idea or your invention or your creation. So, in commenting on the whole Nagi Brooki dispute, individuals, including lawyers, have entertained this idea of patents as potentially being a protective mechanism to use when trying to safeguard your recipes. Notably, however, Section 50 of the Patents Act 1990 explicitly provides that inventions which are capable of being used as food and are mere mixtures of known ingredients are not subject to patent protection. And I think that the deliberately high threshold here is obviously because it wants to ensure that recipes which don't involve complicated or ingenious procedures or processes, they're not barred from reimaginings from subsequent authors in their own derivative works, for example.
I think that's what's also interesting about patents is that a patent application has to be made in order for the right to be conferred. This is unlike copyright, which does not require any formalities such as registration or an application. Copyright subsists as soon as it's been expressed in written form or recorded. So when a patent gets accepted, even where it is another inventor can prove that they've devised or created the invention first, that won't matter. With Nagi and Brooki, the timing of the recipe development has proven to be a salient issue in this case, which of course would not have mattered if either party had had a patent. But as you said, patents demand an incredibly high threshold, and if they were to be conceivably applied to recipes, and in this matter, we're dealing with caramel slice, I imagine it's not super technical.
Yeah, like I really like to bake myself, and I think if I didn't reference a recipe and I was to make a caramel slice, I would kind of know what to include and how to do it. I don't think there's not a lot of components required. There's definitely not a lot of technical elements to it, as say would a patent for pharmaceutical drugs. And I think there's not a lot of creative movement in a caramel slice. It can't be that different. You can't go and add all these ingredients that just don't belong in a caramel slice. So I think it's hard to kind of say, oh, your recipe was super different or it wasn't super different, when there is really only kind of one kind of way to go about doing it. So I think that's also something to acknowledge in this debate.
Timing has proven to be an issue here, but we have to keep in mind that expression in a tangible form is really all that matters. And on that point, Nagi has Bellamy beat here. Bellamy did, however, post a photo on her Instagram showing her caramel slices, I believe back in 2016, stating that she's been using the same recipe as in her cookbook 4 years prior to what was published in Recipe Teen Eats cookbook. Now, assuming Bellamy can prove the expression underpinning this established recipe of hers predated that of Nagi's, what kind of copyright concepts are we actually dealing with?
Yeah, and that touches on a really, really interesting point in copyright. So the idea of independent creation, which is a complete defense to a claim of copyright. So independent creations, this idea that two authors independently of each other have managed to create works that are substantially similar. So in circumstances like these, despite the similarity being between the two works, if it can be proved that the allegedly infringing author created the work on their own, independent of reading the other piece of work, both works will actually be afforded copyright.
Exactly. And in the event that the matter was litigated and Bellamy's work was found to not be afforded its own copyright protection, as a separate expression, of course, the onus would be on Bellamy to prove this. But all things considered, I personally don't see the matter going to court. And this is notwithstanding comments made by Blair Bevan suggesting that Nagi going to court would be an overreaction. I think what Nagi wants is attribution and to be given credit where credit is due. I think not only is this a normative principle, but it's actually codified in the legislation itself with Section 193, subsection 1 of the Copyright Act, reading, "The author of a work has a right of attribution of authorship in respect of the work."
And that seems to be Nagi's point from the get-go. Even in her blog post bringing light to the issue, she asked that Penguin withdraw the book containing plagiarized recipes from sale and either attribute or remove her recipes from future reprints of the book, and to make a substantial donation to the charity in lieu of financial compensation. Just quickly on that, noting that she did take a lot of issue with the fact that Nagi runs a food drive and a lot of her profits do go to this food drive. So I think that's probably feeding into the fact that why she's asking for the charity side of things as well, just to explain that for the listeners. Further down the blog post, she addresses Brooke, saying that had Brooke asked for her permission, she would have given it and it costs nothing to credit. I think these statements ultimately harken back to our earlier discussion on plagiarism and that it's really an ethical dilemma as opposed to a legal one. The conversation surrounding this dispute, whether facilitated by involved parties or not, seeks to conflate plagiarism and copyright infringement, knowing that the former is not a channel for recompense.
Yeah, I feel the same way. I think does Nagi need to litigate anymore anyway? So if we think about it, the court of public opinion has, in many circles, already made its mind up of the situation to say that Brooke hasn't suffered some kind of loss. So even in her return to social media, she took a brief hiatus, which is big for Brooke on TikTok. She discusses some of the ways the situation's negatively impacted her. And not to play devil's advocate, but many people seem to think making a blog post accusing someone of something that is yet to be even more conclusively established was the wrong move by Nagi. Not to mention that if it was the case that the recipe was independently created, why would Brooke accredit it anyway if she did on her own make up this recipe?
Yeah, well, I mean, that depends if you can interpret Brooke's most recent claim that none of her recipes are invented as meaning that one inspiration for that recipe was Nagi herself. In any case, we can see that the copyright frameworks surrounding this kind of area and this kind of dispute are very, very complex. Even Nagi herself has been accused of plagiarizing a recipe, which goes to show that chefs oftentimes get accused of copying, whether they know they're doing it willingly or unwillingly. And, well, we don't really know what the case is here. I will say, however, Brooke's early offer to have the recipe removed from future reprints, despite maintaining that she didn't copy any recipe, seems a bit suspicious. Or maybe it was an attempt to avoid litigation. What do you guys think?
Yeah, I don't know. I think that's a really interesting move. I think a book has now gone to print where the recipe has been slightly changed. I think, to give a little clarification on the recipes, Nagi's recipe, I believe, uses condensed milk in the caramel, which apparently is a little bit different. Brooke has now since removed that and gone to a typical, I think, golden syrup caramel. So I think the change in recipes is interesting in this debate. Has she done it just to kind of cease all drama around it, or was she concerned? But I think if it was the latter, then I think the first approach of maybe saying, we didn't do this happening was also a bit confusing to the debate. And I guess another issue at play here is moral rights. And that's what we kind of touched on before, Mariana, with you saying Nagi just wanted a bit of credit given her charity as well. The rights to attribution. So Division 2 of the Copyright Act sets out provisions for the right of attribution of authorship. In other words, an author of a work has the right to be identified in accordance with the Act if an attribute act is done in respect to the work. So as per Section 194, subsection 1, making an adaptation of a literary work is an attributable act. So, had Bellamy clearly and reasonably promptly identified Nagi as the author of the works, perhaps this whole dispute might not have even happened. However, as we discussed, in respect of generic recipes that have been reproduced en masse for decades or even centuries, it's hard to say whether this argument would hold. And I think that also brings another kind of argument into play. So as you mentioned before, Fadi, there was also claims against Nagi that maybe she had copied a recipe. And I had a little bit of a look into that. And the recipe at hand that we're talking about, so Nagi did actually put a note on the page saying, this recipe is adapted from a certain celebrity chef. I made a change to the salt and cream. And to me, that did seem like fair credit. It was on her page. It was well displayed. As soon as I went into the recipe, I saw that. But that celebrity chef then came out in conversation with this debate and said, I would have liked more credit. I would have liked it to be in a bit bigger of a note. And I guess then that's also an argument. Then what is credit?
Yeah.
What is enough attribution?
A whole other can of worms.
Yeah, it is a whole other can of worms.
Yeah,
so
exactly.
I think it's really complicated with recipes. And I think when you're drawing inspiration and influence from other people, it's always going to be convoluted as to who owns it and who was inspiration. So this dispute between Nagi and Brooke has really highlighted the complex intersection between creativity, inspiration, legal protection in the food world. And the public was really quick to assume the worst. The legal reality is far more nuanced. So what are our key takeaways here?
Well, I think the first key takeaway is that copyright protects the expression of an idea, not the idea itself. Recipe concepts like caramel slices or like baklava aren't protectable, but how they're written, so the written expression itself, could be protected by copyright.
Yeah.
Exactly. Caramel slice recipes especially, they're very simple recipes with a very limited creative variation. So I think the first takeaway is that copyright protects the expression of an idea, not the idea itself. Recipe concepts like caramel slice or like baklava aren't protectable, but how they're written, so the written expression, might be copyright protectable. So what we have here is an example of a simple recipe with limited creative variation, and invariably that means it's going to face significant challenges in gaining meaningful copyright protection.
I think another takeaway is plagiarism does not equal copyright. Again, repeating what we said earlier, they're not synonymous nor mutually exclusive. Plagiarism is more an ethical violation. It's a moral issue with no legal recourse under statute or common law, while copyright infringement is a legal cause of action under intellectual property law. And understanding this distinction is crucial when advising clients on these type of content disputes, especially in the age of digital creation where these can be really tricky to navigate. So it's important that these things are clear and communicated to people.
Yeah, definitely. And I think one of our other takeaways and something we discussed was the idea of independent creation. It is a complete defense in copyright claims. And that's possibly what could be used in the case we have here. So if an alleged infringing work was created independently, both works can coexist. So with their own copyright protection, regardless of the similarity. This onus falls on the alleged infringer to prove independent creation. Making documentation of the creative process is vital. And that's potentially something, if Brooke could, show that she developed this recipe so many years ago, it might be a case of independent creation, and we just have two people with a fair bit of notoriety producing a simple recipe the same way.
Yeah. Another takeaway is that moral rights and attribution matter. Going back to section 193 of the Copyright Act, even where copyright infringement may be difficult to prove, moral rights violations can still be actionable. So the failure to provide proper attribution can damage professional relationships and reputations, particularly in these creative industries that are heavily online, and it's very visible when these mistakes are made.
So obviously the discussions concerned a lot of legal frameworks, a lot of case authorities, but I think one thing that we should keep in mind is that there are practical consequences beyond legal liability. Yeah. For example, we referenced the court of public opinion, and that can have more damaging and more immediate consequences than formal litigation, especially in realms like the social media, which I know both chefs happen to engage with. This case demonstrates how social media disputes can lead to real business impacts. Publisher interventions and reputational damage, even without successful legal action. Sometimes strategic non-litigation might be the best approach.
Yeah, I think that's a really interesting point here. Both Brooke and Nagi are really present on social media. And I know in the month following, Brooke had her comments off on TikTok because of the public opinion was so engaged. And I think that can, yeah, as you said, have as much damage as could like a litigation.
Yeah, actually, like even on that, Fadi and I were talking earlier about the fact that these plagiarism allegations, if they're unfounded, could even result in defamation against
Yeah.
Nagi, which we'll leave that discussion for another podcast because we're running out of time. But that's all for today's episode of Trial by Podcast. Whether you're Team Nagi, Team Brookie, or somewhere in between, we hope we've helped shed some light on the legal complexities behind what initially might have seemed as a straightforward case of recipe copying.